I think it's our time to start this session. Distinguished colleagues, friends, and panelists, welcome to today's online session, which will focus on a very interesting, but I think less developed topic, that is the in-house costs in international arbitration. Before we start, I would like to mention two housekeeping matters. First, to avoid any interruptions, all of the audience, please turn off your camera and the microphone during the whole session, except the panelists. Second, if you have any questions, please send us messages. We will select some of them to answer at a later stage. Now it's my pleasure to introduce our distinguished panelists briefly. First one is Elizabeth Chen, Lizzie. Lizzie is an experienced international arbitration lawyer specializing in international commercial and investment arbitration. She has represented both investors and foreign governments in arbitrations under many major arbitration rules such as SEC, LCLA, Exceed, and also including UNSTRA rules. She is ranked as a future leader of Who's Who Legal Arbitration 2022. Congratulations. She obtained her LLM from Yale Law School as a Fulbright Scholar. She is qualified in England and Wales, New York, and New Zealand. Second guest is Lucy. Lucy is an independent arbitrator with much experience as sitting as an arbitrator. She also acts as independent counsel and has extensive experience advising and representing private and sovereign clients in disputes relating to investment treaties, contracts, and national investment legislation. Lucy is also a sessional lecturer in international arbitration, part-time at the University of Queensland, Australia. Our third guest is Cunyuan Zhang. Cunyuan is the chief representative of Singapore International Arbitration Center in China. She is responsible for overseeing SIAC's activities in China. Prior to joining SIAC, he worked in a leading Chinese law firm in Beijing and has represented clients in commercial arbitrations and related lawsuits. My name is Zongnan Wu, a lawyer at V&T Law Firm, also specializing in dispute resolution, including arbitration and litigation. I also have some experience in international arbitration. Without further ado, I would like to give this floor to our distinguished guests, Elizabeth Chen and Lucy, to share their research results with respect to this very interesting topic. Okay, cool.
Thank you so much, Zongnan, for the very kind invitation. And the reason for today's webinar, the recovery of in-house costs, is also thanks to Lucy Martinez. Lucy and I were former colleagues at Three Crowns, and she invited me to co-author a chapter of a book called Arbitration in England 2030 Vision. I also want to thank Greg Fullove, who is the editor of this book, for the opportunity to contribute to it, and I'm very excited to share our research findings today. Now, in this chapter, we make the very simple point that in-house costs can and should be routinely claimed for. As tribunals are more and more likely to adjust costs, parties should be ready to claim for such costs. This is because, as the winning party, they have been required to incur costs that they shouldn't have had to incur. We're going to focus on the position under English law and general arbitration practice, and I understand that Cunyuan and Zongnan will look at the position under their respective jurisdictions. In this webinar, Lucy and I will divide our allocated 40 minutes into half, and I'm going to be focusing on a category of in-house costs, which is in-house legal costs, whereas Lucy will focus on in-house management costs. And specifically in my presentation, I'm going to focus on 5 topics. The first is to provide you with a basic overview of costs in international arbitration and general approaches to cost allocation. The second is on the evolving role of in-house counsel in international arbitration. The third is on arbitral practice regarding the recovery of costs of in-house counsel. The fourth is the position in England and Wales, and if we have time, also the position in the US as a comparison. And fifth, practical considerations that have arisen during my conversations with in-house counsel on this topic. So let me begin with the first topic, which is a basic overview of costs and general approaches to cost allocation. And I'm going to cover 3 subtopics, which are what are costs, why it is important to consider costs, and whether they're recoverable. So turning to the first subtopic, what are costs? The term costs refers to money that a party spends in conducting an international arbitration. And there are 2 major categories of costs, which are legal costs and arbitration costs. Legal cost generally refers to the cost of retaining counsel, as well as counsel's administrative costs, such as factual investigations and research, data and document processing, and the cost of retaining experts. Now, the other category, arbitration costs, typically include an arbitral institution's administrative charges, arbitrators' fees and expenses, costs for experts retained by the tribunal, and other costs such as renting facilities, transcription, and interpreter services. Now, the focus of my discussion is going to be on the first category of legal costs, and specifically only costs incurred by in-house legal counsel, as opposed to external counsel. Now, turning to the second subtopic, which is why is it important to consider recovering these costs? Now, it's important to recover these costs for the simple fact that you might be able to recover them. If you win in an arbitration, you may be able to claim back the legal and arbitration costs that you have incurred. And this would be over and beyond any substantive damages that you may claim. And Lucy will mention later that there's no double recovery here when we discuss this topic. Now, moving to the third subtopic, which is, are costs generally recoverable? And the answer is, it depends. Determination of who can recover costs and in what amounts depends on the applicable law or the parties' agreement to the extent permitted by applicable law. Cost decisions are usually made at the end of a proceeding and after a final award has been rendered. Now, assuming that costs are recoverable under the applicable laws and regulations and agreements, there are generally 2 approaches to cost allocation. The first is that costs follow the event. This is where the winning party gets to recover its costs from the losing party. The justification is that the losing party has caused the winning party to incur costs of conducting an arbitration, so the winning party should be effectively indemnified for costs incurred. So, for example, tribunals have broad discretion under English law to allocate costs as they see fit, but the English Arbitration Act also requires tribunals to apply the principle that costs follow the event. As you can imagine, this principle isn't always straightforward to apply, especially if there's no clear winner or loser, because each party has succeeded partially on their claims and counterclaims. As an alternative approach, commonly used in the United States, is that parties each pay their own way. A further alternative is that the parties can actually agree, and this is permitted under English law in advance on what costs are recoverable. So having just provided an overview of costs and the recovery, I'm going to now turn to my second topic and the meat of this webinar, which is on the recovery of in-house legal costs. In particular, I'm going to focus on the recovery of the costs of time incurred by in-house counsel in any particular case. Now, it is important to talk about the role that in-house counsel play in a case, because it will be directly related to whether it is worth trying to recover those costs. If in-house counsel have a fairly limited role, for example, in supervising, instructing external counsel and supervising the work at a high level, it may not make sense to try to recover in-house counsel costs. And this is especially so if the proportion of the in-house costs is relatively limited proportionally to external counsel's fees. However, it is increasingly the case that in-house counsel play a greater role than just supervising external counsel. And this may be particularly true for large companies which are bringing more of the disputes work in-house. But for smaller companies, this may not be feasible and they will still need to outsource most of the work. Now, in-house counsel have many roles, which might include developing case strategy, appointing the tribunal experts, issuing holds to relevant staff, collecting documents, performing an initial review of documents, arranging for storage of documents in a database, conducting interviews, reviewing pleadings, participating in the selection of arbitrators and experts, arranging a mock arbitration, etc. Now, increasingly, what we've seen is some institutions have been recognizing the increased role of in-house counsel. And for example, the ICC has adopted the specific aim of increasing in-house counsel engagement in the arbitral process and recognizing their modern role as C-suite level advisors to their organizations and assessors of risk. And what this means in practice is the ICC President Claudia Salomon has encouraged ICC tribunals to consider copying in-house counsel and communications from the tribunal, involving them, for example, in the case management conference, so that the arbitral process best aligns with parties' expectations. So the more in-house counsel are involved in the arbitral process, the more time they're going to incur in the matter and the greater the cost will be. And in turn, the incentive for claiming those costs will be greater. Now, through my conversations with in-house counsel, my understanding that there are some cases which are run entirely by in-house counsel. So this might not be true in a bigger, more complex case, but where you have a case that maybe where it's not so complex to do the document production and where the matter involves a fairly straightforward issue of black letter law, you might have a situation where the in-house counsel is running the case almost entirely. Now, having discussed the evolving role in-house counsel in the arbitral process, I want to turn to my third topic, which is general arbitral practice regarding the recovery of in-house counsel costs. Now, in summary, the general trend is that such costs are in principle recoverable, subject to substantiating it with sufficient evidence, and the work not being duplicative of external counsel's work. Now, many arbitral rules empower tribunals to award costs, but most will leave it to the tribunal to determine which categories of costs are recoverable. So, for example, the LCIA rules define legal costs as legal or other expenses incurred by a party, but the rules don't actually explain whether they include in-house counsel fees. Now, the prevailing approach in international arbitration seems to be that in-house legal costs are, in principle, recoverable, provided that they are, 1, directly connected with an arbitration, 2, go beyond mere management involvement, 3, don't overlap unreasonably with external counsel fees, 4, are reasonable, and 5, are sufficiently substantiated. Now, commentary suggests that ultimately the recoverability of in-house costs turns on proof and justification, i.e. where in-house legal costs can be justified by reference to billed time, hourly rates, and proof of when and why those hours related to the arbitral proceedings. All that said, tribunals haven't necessarily been consistent in awarding in-house legal costs, and detailed reasoning on costs is not always provided, or the awards may not provide the full financial data on which a cost decision has been made. So now, having looked at international arbitral practice, I will now briefly describe the position under English law and, time permitting, on US legal practice, respectively. So let me begin with the first subtopic, which is the position under English law. The position under English law is actually pretty well established. The English Court of Appeal established in 1974, in a decision called Re Eastwood, that in-house counsel costs are generally recoverable. The court stated that in-house counsel costs could be benchmarked against a reasonable hourly fee compared with the work of an independent solicitor. The court considered it important that in-house costs do not infringe the indemnity principle, i.e. the principle that recovered costs should be no more than an indemnity to compensate the counterparty for the expense that has been put in the arbitration. More recent decisions, such as the court's decision in Ultraframe, the Court of Appeals decision Ultraframe, have also emphasized that in-house legal costs are recoverable, so long as they are not duplicative of the work done by external counsel. Now I'm going to turn to my second subtopic, which is US practice. Now we also looked at US practice for the simple reason that there was the most jurisprudence here, especially after our research on England and Wales. Now, as mentioned before, US federal litigation, the general principle is that each party pays its own costs. However, in US litigation, the practice has also varied between state to state as to the recoverability of legal costs. Now, what's particularly interesting is how the US courts have calculated in-house counsel fees where they have decided to award them. And in US practice, there are two key approaches, two principal methods for assessing these costs. That first approach is the lodestar method, and the second is the cost plus method. Now, the first lodestar method is actually similar to the English approach, where in-house legal costs are benchmarked against the billing rate of external counsel having comparable experience, reputation, and skill in performing similar services. The second is the cost plus method, which takes costs actually incurred with adjustments to reflect actual time spent on the litigation and an appropriate allocation of overhead expenses, for example, costs in relation to office space, office equipment and supplies, legal research, and similar expenses. Now you might ask, which approach is more commonly used? The first approach, the lodestar method, is actually more commonly applied because it's easier to calculate. However, some courts have preferred the latter approach because they consider it to be a more reasonable measure of in-house counsel fees. Now, having talked about the arbitral practice generally and the positions in England and Wales and in the United States, I'm now going to talk about some practical considerations that have arisen through my conversations with in-house counsel. Now, I talked to my in-house counsel friends because I felt like there was a conundrum. So if in-house legal costs are recoverable as a matter of principle, then why don't we see it happening more often? And I wanted to share a couple of insights that I've gained. The first is, as mentioned before, recovering in-house counsel costs is often a matter of proof and substantiation. And in some ways, the kind of the best proof that you can provide would be time recording and narratives. A few of the in-house counsel that I spoke to felt that requiring in-house counsel to keep time would require a major cultural shift. In fact, one of the reasons why in-house counsel have moved in-house is because they didn't want to keep recording their time in the detailed way that external counsel do. Moreover, some of my friends said that keeping time is time consuming, especially for people who aren't used to doing it. And one of the in-house counsel I spoke to wasn't sure that keeping time would be worth the inconvenience for the off chance that the client might win the case and get an award. Second, and all that said in my first point, is that the evidence required may not necessarily be a detailed set of time records in the same way that external counsel would provide. An in-house counsel that I spoke to said that in one particular case, the way that she reconstructed her time records was to look through her emails and to make a general estimate of the time that was spent on the matter. She ended up discounting her time by 50% so that there could really be no grounds for an argument that the claims weren't reasonable. One of her suggestions, though, was if you are intending to claim in-house counsel costs later on in the arbitration, it does make sense to consider at the outset, for example, including it in PO1 or discussing it at the case management conference, that in-house costs are a category of costs that the parties intend to claim for. And it could be useful at the outset for the parties or the tribunal to provide some direction as to the nature of the evidence that they would consider necessary in supporting such a claim. And the third point is that one in-house counsel said that in his 20 years of experience, in-house costs are simply, as a practical matter, not recoverable. He said that he had never been successful in recovering in-house costs, but equally, none of his counterparties had been successful in claiming those costs against his company either. He said that the typical reasons offered for why this is the case included in-house counsel supervise but don't contribute materially to the outcome of the case. In-house counsel are too involved in too many matters for the cited number of hours to be accurate. In-house counsel don't bill their time hourly, so the calculation of an hourly rate is too remote. And another reason is that an award of in-house costs would be punitive. The fourth insight I want to share is some of my in-house counsel friends have been concerned that disclosing time records would reveal confidential information. However, other in-house counsel that I've spoken with have said that with appropriate redaction, the disclosure of confidential information, maybe about in-house counsel salaries, for example, if that's relevant, or the particular work, those issues can be dealt with through appropriate redactions. Now, this brings me to the end of my presentation. So let me end with 3 key takeaways. The first is that in-house counsel are playing an increasingly significant role in the conduct of international arbitral proceedings, and their time should be recovered, or at least their companies may have an interest in recovering those costs incurred. Second, in principle, in-house legal costs can be recovered, but they do need to be properly substantiated. And third, keeping time may not practically be feasible for in-house counsel, but acceptable evidence need not necessarily be detailed time records of the nature that external counsel keep. A reasonable discount on fees might still make those costs reasonable from a tribunal's perspective. So with those 3 takeaways, I'll end my presentation here and pass the floor to Lucy.
Great, thank you very much. I will now hopefully share my screen, technology permitting. Lizzie, can you see my slides?
Yeah.
Excellent. Let me try and go to slideshow. So hopefully you can see it in slideshow format now. So thank you very much to V&T Law for hosting us today. And you've already heard from Lizzie, she's covered concepts 1 and 2 on this overview slide. And so it's up to me now to cover topics 3 and 4. You've heard that she spoke to you very eloquently, if I may say, on in-house legal costs and covered the issues that come up. And I'm now going to talk to you about management and employee costs. So the other category of in-house costs that Lizzie mentioned at the outset. And you can see under bullet point 3 or item number 3, that they're the points I'm going to cover today, which largely tracks the points that Lizzie covered already in relation to in-house counsel. And as she explained, this tracks our chapter in a book that's coming out this year. And just to give you a little bit more background, the background to the chapter is an arbitration I was involved with a couple of years ago as arbitrator, where governed by English law, LCIA rules, and one of the parties claimed their in-house legal and management costs, both categories of costs. And they submitted English law on this point, these cases, some of which Lizzie has spoken about. Now, the caveat is those cases are in the context of litigation, not arbitration. So the recoverability of in-house costs in the context of English court litigation. But the principle would apply equally to any arbitration governed by English law, as Lizzie explained. And I personally, perhaps to my embarrassment, was not familiar with that jurisprudence in relation to in-house costs under English law, the litigation authorities that relate to that. And that's why I thought it would be good for us to raise our collective awareness in relation to these cases. And perhaps, as Lizzie has said, maybe start the cultural shift once you realise that as a matter of principle, these costs are recoverable under English law, then it can start to change the practice of us as counsel and as arbitrator in terms of claiming and in our arbitrator capacity awarding these costs. So this is what we're covering today. I won't read what's on the slides. They're really there. I'm pretty confident you guys can all read at this point. And many of you, in fact, all of you are much more clever than I, and you can read in English and in Mandarin. I'm sorry, these are in English only. But in terms of the roles of what they do, as you would all know from your own work, working with clients, your clients, our clients, when we're acting as counsel, both the in-house lawyers, but also the in-house managers, in the C-suite, and the other fact witnesses that you might work with, or just general technical folks within the client. So management people, but also general employees, the non-management ones, they play critical roles in relation to arbitration, usually behind the scenes, i.e. their names aren't on the record. We're not talking about employees who are appearing as fact witnesses, because usually those costs are recoverable as part of the arbitration costs. These are the people who are not appearing on the record, but are assisting the arbitration behind the scenes. So what I'm talking about is not the in-house lawyers, but the in-house managers and employees. And from the English law authorities that we're going to look at, and of course, those English law authorities are persuasive in common law jurisdictions which are based on English law, which includes Hong Kong, Singapore, Australia, New Zealand, Canada, lots of other countries that still at least are interested in English law authorities, even if they're no longer binding. And when, as we'll see in a little bit, those cases say, well, look, these employees, their time has been diverted. If your job is normally to interface with customers or assist in the manufacturing of widgets, and your time has been diverted from doing those jobs because you have to deal with this arbitration, and therefore you've had your time diverted and you'd otherwise be generating revenue for the company, then that's part of the principle as to why these costs should be recoverable. Now, as Lizzie mentioned, there is a legal distinction between recovering management and employee costs, which, just by way of shorthand, I'll refer to as management costs, because it's a bit unwieldy to say management and employee, but I'm referring to both together. So there is a distinction between recovering management costs as an element of damages, where it's part of your damages claim in the arbitration. And you can do that certainly under English law and under most common law systems, and potentially under civil law systems as well, but you would know better than that. There's a distinction between recovering it as damages or recovering it as costs. Now, our focus today is on recovering it as costs, but as Lizzie has mentioned, you can't do both. You either do it under damages or you do it under costs, but you can't recover it under both. So that's the overview of what are we talking about in terms of management costs. In terms of arbitration practice, consistent with the practical point that Lizzie made at the end of her presentation, with the person with 20 years experience says they've never successfully claimed it, but nor have they ever been successfully claimed by opponents. Management employee costs are often just not claimed. And again, well, for a bunch of reasons, they're not claimed, and we'll come back to that. But there was this ICC review of ICC awards that were issued over a 6-year period, 2008 to 2014. That's now out of date because it's 7 years ago. But I would say when they do the next review of this, there'll actually be more cases awarding costs. But at least back then, you can see the summary on the slide as to what the outcome of that ICC review was. Basically, there was a whole bunch of different approaches taken by tribunals. Some tribunals say you cannot recover management costs as a matter of principle. Some tribunals say, okay, maybe you can recover it, but you've got to prove it. And that touches on the proof points that Lizzie mentioned earlier, and we'll come back to, or that sometimes tribunals have awarded it. So there's been a range of approaches in relation to arbitration. As you all know, based on your practice, one of the challenges in this area is the confidentiality of arbitration awards. So it is hard for us to find arbitral practice, which is why these sorts of reports are so interesting. And the chapter goes into some other cases that other awards that we won't go into in the interest of time, awards that have become publicly available and looks at the allocation of costs therein. So we can see arbitration practice, a variety of approaches taken. The key point is it's not like every tribunal is saying no way can you recover these costs. Some tribunals say, yes, you can, as long as you have proof satisfied. So we also look at commentary in international arbitration. Because so many awards are confidential, commentators have a great role to play in international arbitration to guide us as to what are the right principles for us to apply. So just to be clear now, this isn't just English law governed issues. This is international arbitration generally. So could depend, it could be common law, could be civil law. This is the broad amorphous idea of international arbitration generally. And you can see that in relation to commentary, the first two quotes say, yeah, there's no reason why you shouldn't be able to recover management costs. But there is the third quote on there suggests, at least by analogy with what domestic courts have done in America in relation to litigation, then you shouldn't be able to recover management costs in arbitration. So, and you can see that that last sentence on the last quote says maybe you should be thinking about making these claims for management costs as a head of damages, consequential losses, if that's recoverable, as opposed to costs. But in any event, you can see there's a variety of approaches taken by commentators. So then moving on to, oops, I think I've missed. So in terms of the English case law, and this is what one of the reasons that we wanted to write this chapter was to raise awareness of the English cases that relate to the recoverability of in-house costs. You can see what I've touched on already, that at least in the context of litigation, English courts have consistently accepted over the last few decades at least that you can recover in-house costs. Historically, there was an exception. Historically, you could not recover management costs, but there have been various exceptions developed through case law over the years. The slide has citations for those of you who are super keen to read up more about this, or just wait and read our book chapter, which summarizes it. So this is for those cases that are governed by English law. You have these English case authorities saying in the context of litigation, and we would extrapolate from that to say this also applies to arbitration, then you can recover management employee costs. So based on that quick canter through international arbitration practice, international arbitration commentary, and English case law, these are the 5 principles that we say apply to claims for recovery of management employee costs in international arbitration. Because the chapter is on English law, the book is on English law, the chapter focuses on English law, but I would submit that these 5 principles are actually generally applicable to most international arbitrations, unless your governing law carves out recoverability or has some sort of domestic jurisprudential thread that says in-house costs are not recoverable in litigation or in arbitration under your domestic law. But I think these are 3 basic principles that would apply. They are similar to the ones that Lizzie outlined in relation to legal costs. You can see the starting point is that they are in principle recoverable. That's the game changer starting point that we go from there. Provided that you're actually related to the dispute. It can't be tangential work. It's got to be directly related to the dispute. And one of the other key points, it can't be unreasonably duplicative of external and or internal counsel work. So what the management and employees are doing must be different from what the in-house counsel and the external counsel are doing. And just a practical example, in my case that I had as arbitrator, where there was a claim for in-house costs and external legal costs, the parties put in day notes for what the in-house lawyers and the external lawyers were doing. And one of the big issue in that particular case was review of a UK Supreme Court decision X, because it's confidential. There was a big case came down called X, and the lawyers all had to review what were the implications of case X for our arbitration. And on the day notes of the in-house lawyers, there was review of UK Supreme Court decision X, and that same time entry appeared on the external lawyers. So that's the sort of thing that you can't get both. Like either you have your in-house lawyers review it and summarize it for the external lawyers, but more practically the way it works is the external lawyers review the UK Supreme Court X decision and summarise its relevance for the benefit of the client. So it requires quite careful work on the part of the tribunal to go through the day notes, and you'd have that for the managers and employees as well. But the key point is that you can't duplicate work, you can't get double recovery for the same sort of work. And you can see some of the other elements here. That point 2 was an important one that English courts have emphasised, but I think would apply in all arbitrations governed by English law or otherwise. You can't get an element of profit through here. It's really just recovering for the lost employee or management time that's been spent on a particular dispute. The third point relates, number 3 rather, relates to proof. The sorts of, like anything in international arbitration, the party asserting it must prove it. So if you're claiming these costs, you must meet your burden of proof by submitting appropriate documents. And you can see the examples on the slide. On the arbitral practice, there have been quite a few cases where tribunals have said, look, all you've got is one email from the employee saying, I'm claiming randomly, £10,000 for the time I've spent on this dispute. And that's not sufficient. You haven't met your burden of proof in relation to that. You've got to go through the supporting documents. Point number 4 relates to all costs decisions. If the quantum of the dispute was, let's say, 1 million Singapore dollars, and that's the amount that's awarded in the arbitration, and the total costs claim was for 800,000 Singapore dollars between external counsel, in-house counsel and in-house management employees, you are very unlikely to get back $800,000 in costs on a $1 million award. So, you've got to have a proportionate claim of costs that's proportionate to the amount of the award. And I think that's actually one of the reasons why in-house costs, whether it's legal or employee costs, are not more regularly claimed. Sadly, as we all know, or happily in our counsel hats, often the biggest part of the costs are the external counsel fees. So if you're already claiming a lot of money in external counsel fees, there can be a reluctance optically to add a component for in-house counsel and or in-house employee fees. But that doesn't mean they're not recoverable. And certainly if you're super efficient in all categories, these costs should be recoverable. And point 5 is again, that double recovery point. So some final thoughts, the conclusions and practical tips. You can see the starting point is in-house costs, so both legal costs, as Lizzie touched on, and employee management costs, as I've discussed, they are recoverable. We've put up some certain considerations for everyone in the process to think about, both the parties, i.e. our clients, the customers, the companies and individuals themselves who are the parties to the arbitration, but also the external counsel to think about in the context of costs. Some considerations for tribunals to think about. These are on the slides, which we can circulate afterwards for those who are interested. You can email me to get a copy, or in any event, they'll be available for those interested. I just added that last point of the second bullet point, the final point I added while Lizzie was speaking about this idea about a cultural shift. Is it time for a cultural shift? I would submit yes. In relation to our approach to costs, yes, it can be time consuming and inconvenient, but if you do it from the outset, it's not that time consuming or inconvenient, the way all of us track our costs, whether you're as counsel or as arbitrator, and you potentially get it all back. And you can see that last bullet point on this slide is the reason why, in my view, this is valid as a matter of principle, leaving all the law aside, just as a matter of justice and fairness. The basic idea is that if you win a dispute, whether it's litigation or arbitration, you should be offset for all the harm that's been done to you. So you get back all the money that you lost as a result of the other side's contract breach, and you get put in the same position as if the contract breach had never occurred, or the treaty breach in a treaty case. And if, as a result of that breach, you had to spend all this money on external counsel and you had your internal lawyers and management time significantly diverted to the dispute, then you should be able to recover that as a matter of justice and fairness. So on that lofty note, I've got a couple of quotes up on the final slide just to finish up on. These were, the first quote was from 2014, and we would say it's equally applicable 8 years later in the pandemic context, that as we've all seen, at least I've seen in my practice, both as counsel and arbitrators, our clients in my counsel role have an incredibly important role to play in winning arbitrations and in arbitrations generally, and we should be recognising and compensating them for their valuable roles in that. And that the Baltag quote, that often people just look these issues of in-house costs and just think, well, that's just part of the cost of doing business, but it's not, and it shouldn't be. And we submit that it's time for a change in that approach. So with that, let me stop sharing my screen and stop sharing my thoughts, and I will go on mute and hand over. I'm not sure who speaks next. Maybe is it Zongnan, over to you?
Thanks. I think I would like to invite Cunyuan to share some thoughts. Especially, could you give us some thoughts from the perspective of arbitration institutions? I think this is an interesting issue.
Okay, I find it's rather difficult to comment from a perspective of institution, because institution is neutral, and we handle, as I see, we handle mostly the cases based on the Singapore law and English law, and also maybe some of our handle the Malaysian law, Indian law, but generally, but we also handle a handful of cases which is based in the Chinese law or other the laws of the other countries. So generally, I think this topic is very interesting, in particular for the Chinese users. So as for me, my daily job is to promote SIC among the Chinese users. I would introduce the features of the internet. One of the important features of the commercial arbitration is that the winning parties can get the legal costs, all the legal costs from the losing parties. So which is very attractive to some of the Chinese users. As for the costs for the in-house counsel, I think generally the most Chinese users are not familiar with this point, and I also this will become a very important features that the Chinese users should know about, in particular when they are dealing with the international arbitrations, which are mostly based on the English law and the Singapore law and other common law system. Yeah. So generally, I think with the excellent presentations from the Elizabeth and Lucy, I think I learned a lot. In the meantime, I also agreed with their opinions. In particular, that I agree that the philosophies behind this arrangement, that the winning party should get all the costs be compensated. I agree with this philosophy, but I also agree that it is rather difficult to prove the real costs of the in-house or other internal employees, because it is difficult to evaluate the human labors. So maybe in the Q&A sessions after your comments, maybe I think the Elizabeth and Lucy may give us more detailed examples. In particular, so how would you like to advise your Chinese clients to be prepared for this challenge and get as many the comment sessions as possible? So basically, that is my comments. Thank you very much.
But actually, I have one question to arbitration institution, because this related to the arbitration rules. I think the arbitration rules are very how to say, unclear on the definition of legal costs, legal expenses. Do you think it is possible for institutions to define the scope of such costs, or maybe make some efforts to clarify, or give some guidance to do that?
Okay, I see. So what you mean is that to put this rules into our default arbitration rules. So the parties, by choosing the arbitration rules, so they can reach the agreement on the compensation of the in-house costs. I think that theoretically that is possible, but obviously I'm not in a position to answer these questions on behalf of SIC, because this matter is quite important for the institution to decide. I think it would also put a lot of pressures on the institution, in particular the first one who is trying to do so. This approach may or may not be accepted by the market. So I would say that theoretically it's possible, but it's also very challenging to do that, to do this kind of innovation. Yeah.
So I could just give some comments. Actually, as I mentioned before this formal start of this presentation, I said this topic is very interesting but less developed. Actually, I was shocked by such a topic proposed by Elizabeth Chen, because this topic, even the concept of the recoverability of in-house costs, is really rarely shared within China. I think firstly, I would like to raise the question, that is, what law is governing the allocation of costs? I think this is very important, because as Lizzie and Lucy emphasized, the research focuses on the arbitrations mostly governed by the law of England and Wales and the US, I think. But if we look outside, I don't think these kind of approach are widely shared by other jurisdictions. Take China, for example. In Chinese arbitrations, I rarely heard that the parties claim the in-house costs. Even the parties don't know the concept of in-house costs. I shared the reasons which Lizzie have shared with us. Several very important reasons are there. I think firstly that the first reason is that the parties don't consider in-house costs are really costs they can claim from the other party. And I think this is traditional concept. Another reason is that in China, actually the claim for legal costs is rarely supported even in courts. I think I can share the general trend in China courts about the allocation of the costs, especially with respect to contractual disputes. Most courts support the costs even when the parties have expressly agreed that the losing party shall bear the other party's costs. I think such kind of a judicial practice may influence the position of arbitral tribunals. So this leads to the conservative position of the Chinese arbitrations. This is my first comment. The second actually is not a comment, but some questions. I shared the general position that the in-house costs shall be covered, but how to calculate the amount of in-house costs, I think this is a little bit difficult in practice. My thoughts are twofold. First, how to determine the time range. What I mean is that actually before the formal initiation of the arbitral proceedings, the company may have spent a lot of time in negotiation and mediation. My question is, Such time spent in mediation or negotiation shall be included into the calculation of the costs, or the tribunal only generally support the time which has been spent only after the initiation of the arbitration proceedings. This is my first question. The second question is, we know that if a has emerged, the company will gather a large group, especially when the company facing a very complex dispute. The company will gather a lot of in-house employees, in-house counsels to discuss and to make strategic plan to handle the dispute. My question is there any limitation on the number of the employees or the status of the employees? I think these two very important questions when determining the amount of cost. I want to Elizabeth or Lucy to give us some thoughts. Thanks.
I'm happy to offer some thoughts to start with, Lucy. There were so many really interesting topics there. On the first topic about governing law, we actually look at this in the chapter. So your question was what law governs costs issues, and there's quite interesting commentary by Gary Bourne, who says there's probably little doubt that the procedural law, which would normally be the law of the seat, would govern issues of costs. He also says that there's a compelling argument that it's the substantive law, i.e. the law governing the underlying contract, that should apply to, that should be the applicable standard for cost allocation. But then he says maybe the most compelling position is that the award of cost should be a matter of international arbitral practice. So what is like the jurisprudence that's really arisen from like arbitral awards in general. And I think I need to look at this a little bit more closely, but there's been reports such as the one done by Bickel and Allen Overy on costs recovery in international arbitration. I think increasingly we are seeing more and more investment treaty tribunals adjust costs so that the loser pays. There was a very interesting comment as well on whether you include costs that were that occurred like during sort of the investigation and case assessment stage. I think that's such a great question because that's probably most or a very significant chunk of the work that's put in by in-house counsel when they first like become aware of the legal issue. They start talking to their employees. They consider whether they have they even have a case that they want to bring, and they bring in external counsel. I'm not actually familiar in arbitral practice. Some maybe Lucy will know. Instinctively, I feel like those costs should also be included. My understanding is that when we claim costs for external counsel, you would generally include all of the time that you have incurred on a particular matter. And I think that would include pre-arbitral steps as well. But I'd be interested in Lucy's comments on that and where you should start calculating. I think also another thing is that in reality, or at least in my limited experience, there's not often very much evidence that is provided even by external counsel to substantiate costs. So like, you know, some of the cost submissions that I've seen, all you actually have to put down is the final amount or the amount that you would like to claim. And then you have somebody from your law firm sign off and say, like, this is a true and accurate figure of the amount that we've incurred. And it's been rare for me to see international arbitral tribunals really like even one ask for like a line by line breakdown of costs for external counsel. I'm not sure external counsel, arbitral tribunals really want to spend too much time on that aspect anyway. And I think that might be a little bit different to litigation in the English courts, where I think there might actually be like maybe a separate judge. That's why I would need to clarify, but there might be a separate process of taxation where you look at the costs. There's a practice of looking at the costs in a more detailed way. And then I just wanted to address one final point, which is what Cunyuan mentioned about what's our advice for Chinese in-house counsel when it comes to recording time. What my suggestions would be universal. like the best evidence that you can provide is probably time recording and narratives down to the minute of how much time you spend on something. But of course, for the reasons that I've discussed, that's not always possible. So any evidence is better than no evidence. And often what's like a good way to approach this is to provide some kind of reasonable discount at the end. So you say, I think it's around like this amount of money and I'm going to discount it by 50%. And that often kind of like takes the wind out of the sails of an argument that like the timing is not accurate. And also one suggestion for management costs is maybe external counsel can help record the time. So anytime that's on like Zoom meetings or prep meetings, that time can be recorded by external counsel for later claiming, so that reduces the burden on management to do it themselves. So some initial thoughts there.
Okay, so just to go through on various of those excellent points. The first, there was a request for detailed examples of the sorts of proof that could be used. I went far too quickly through this slide. I think for one of the points that we spoke about was, if you're going to do this, you've got to do it right even before the dispute begins. So do it from before the dispute has arisen. You need a timekeeping software in place. That's going to be the easiest way to do it. So you have a system in place, or you do a low-tech solution of just emailing to yourself. Ask your employees to email to yourself. So you have a time and date stamped contemporaneous proof of time spent in relation to a particular matter. And then in terms of the proof that you could do, you put in like an invoice that you get from your external counsel, where you have the day notes and detailed breakdowns. And the principle there is, when you as clients, when you get your bills from your lawyers, if you look at it and say, I've got no idea how you charged me $10,000 last month, I don't know what you did, the proof that you would want as a client to pay your external lawyers $10,000, that's the proof that really you should be looking for to a tribunal. And I know that Lizzie said that it's rare for parties to submit that, but I submit this point here on this slide. Tribunals have become a little bit lazy when they're dealing with costs, and I get it. We're so tired. But by the time you get to the end of drafting the liability and quantum section of the award, it's really exhausting to have to deal with costs now and to deal with it on a very careful basis. But this can be quite a significant chunk of money, and it's important for you as the tribunal to address the proof that's been put to you. And okay, if it's a big case running for many, many years, the day notes would be crushing. And I think in that scenario, that's where you probably wouldn't be putting in the in-house counsel claims, because the tribunal would need to review the day notes to make sure there's no duplication of work. But for the smaller cases, where there's smaller counsel fees, then it may be worth putting in its day notes, not an affidavit from a lawyer, or a statement from a lawyer saying, yes, we've incurred this amount of fees. I think that is good enough for external counsel fees, because it is generally accepted that they are going to be recoverable, provided it's proportionate and reasonable. Often we'll have seen tribunals will apply a 20% haircut because they think the total amount is unreasonable. But I do think tribunals should be paying more attention to costs. So that was the first point. The second is, I definitely agree with Lizzie's point about the evolution of practice, that there is now a trend towards loser pays in international arbitration. And I was just quickly trying to pull up, there's a couple of, so the ACICA, the Australian Centre for International Commercial Arbitration, just amended their rules last year. And you can see one of the points that they make is, so in Australia, governed by or influenced by English law. Now in the updated rules, it says costs shall be borne by the unsuccessful party. And it comes from the 2020 LCIA rules, which hopefully you can see on your slide now as well, that they talk about the relative principle of costs follow the event. Now the ICC rules haven't yet gone as far in relation to that. they just say this is, and they're quite recent. So last year, they just say they take into account the circumstances in which the parties have conducted the arbitration. But I would submit that in coming years, I suspect all of the institutions will be at least referring to this principle in their rules. I know HKIAC don't yet have it, and neither have our good friends at SIAC, but I know that the SIAC are currently updating their rules. So I'll be very interested to see what happens I know that you can't talk about that, but I'll be very interested to hear what happens in the update. The third question about limitation on number of employees. There is no limitation in relation to numbers, but you want to think about the optics of the claim. No tribunal is going to award you for having 15 people, whether it's in-house counsel, external counsel, and managers sitting on a call, and also just the optics of the total number of the claim. And that's my example about if it's $1 million award, you don't want to be putting in a claim for costs for $800,000. So even though there's no strict number, you'd have to be thinking about these things as you're putting your costs claim. Fourth, in terms of where to start the calculation, I think 6 to 12 months before the request for arbitration, we all know the lawyers get involved pretty heavily for big claims in particular, and often there's a requirement of amicable negotiations or some attempt at amicable settlement before arbitration is filed. So at least for me, that would be, if it's 2 years before the RFA, you might start to be thinking that's a bit far out, but 6 to 12 months to me seems reasonable. And my final question, which we might not have time for, is Lizzie, you said in your presentation that you had a client give feedback that it would be punitive to award costs. And I didn't quite understand what that meant. I know it wasn't your comment, but I don't know if you could guess as to what they meant by it potentially being punitive.
I'm guessing, and this particular friend had just given this to me and an email without commentary. I'm assuming that this was something the tribunal had said, that awarding in-house costs would be punitive. And I suppose it would be punitive if you think that it's not really a category of cost that is in principle recoverable. And if you think that like in-house legal costs is just like part of the day-to-day running of a business. So claiming that would be punitive. This just reminded me, I feel like I remember from studying for the QLTS that there might be some kind of cost schedule or fee schedule for counsel in English litigation. I'm not sure if I remember incorrectly, if anybody else remembers, but like I can see some unfairness arising in international arbitration where some counsel might, have very high fees and some may not. So I wonder if there's more we can think about international arbitration about like equalizing the field or having some kind of like reasonable benchmark. Whatever it's benchmarked to, maybe there should be like a reasonable sum of recoverable costs. Yeah, just a thought. So I see. So we see we're at the half hour, so I'll let Zongnan.
Yes, I think there's no more time for more questions and answers. I just quickly to sum up today's session. That's okay, because we have exceeded the time limit. So many thanks to Lucy and Elizabeth to share such a thoughtful presentation with us, especially in a judicial environment where the legal costs are very limited. I think we should look forward. I think the new chapter issued by Lucy and Elizabeth will arouse the discussion about the recoverability of in-house costs in international arbitration community. And I think this will also arouse the awareness of arbitration potential users to whether to draft an arbitration agreement to include in-house costs in the allocation of the legal costs. The second is to guide the arbitration rules to discuss whether such a cost shall also be expressly stipulated in arbitration rules. And the third trend may be that the more and more arbitral tribunals will be lenient on the allocation of in-house costs. These are my closing remarks.